what's going on this
Good
morning?
morning, Norma. For some reason, I don't have my docket. Do you have an extra one? All right, thank you.
Oh. Oh.
Hello.
What do you doing law stuff?
Yes.
Yeah, we're gonna do some law stuff later. Pretty cool.
Okay. All right, thank you.
Make sure your phones are off or on silent, please.
In terms of those options.
Yeah. Oh, yeah, this is not a daycare. You know what the problem is? Do people realize how how many germs are up here? No. Okay, all right, thank you. Yeah, I don't know what happened to my docket.
Okay.
Yeah, I just don't have it.
Okay. Oh, for sure, yeah.
Deputy Laura, I truly don't think people realize how low a child's immune system is and how germy it is at the courthouse. As much as we try to keep it clean.
Told me that I need to mob people to make sure that she knows not to bring the spice. Do you have any paper?
No. I think there's some down there. Okay,
That's part of it.
okay. And Deputy Laura, I think we're gonna have a problem today with that.
Okay.
Anyone that needs French on
Thank you. All right, everyone, I am going to call the docket. When I call your name, please stand so that we will know you are here. If we don't see you, then what's going to end up happening is a warrant may be issued for your arrest. In custody, we have Anita Ruiz, Cristobal Gomez, Juan Carlos Rios. Thank you. George Hawkins. Oh, custody. All right, thank you. Nathan Cruz, custody. Macedonio Martinez, custody. Willie James Cunningham. Thank you. Jose Cardoza. Denzel Apia. Thank you. Mariano Rendon. Matthew Rendon. Aiden Martinez. Yadhara Romo. Am I pronouncing the first name correctly?
Yadira,
Yadira Romo.
the H side.
Oh, the H. Okay. Trevor Morse, jail. James Brandyberg, jail. Kristen Seal, jail. Richard Rodriguez, custody. Christopher Weezar, custody. Well, that's about 4 pages of the docket. Alfonso Diaz, custody. Sonia Hickman, custody. David Aguirre. Nicholas Courtney, custody. Okay, is Sean Chrisman in custody?
Yes, sir.
All right.
Yes and no, he's an electronic work release.
All right, thank you. Kendrick Ward.
Here.
Armando Garcia, custody. Amberly Perez, custody. Mark Lewis, custody. Brittany Brown, custody. Christopher Dunning, custody. Manuel Sandoval, custody. Alvo Tucker, Jose Gonzalez, Frank Torres, Felix Apolinar, custody. Linda Rose Ali. Linda Rose Ali. Jaime Torres, custody. John Anthony Martinez. Thank you. Chet Baker. Lucienne Miranda. Thank you. Dirkland Davy. Jalen Zavala. All right. All right. Is there anyone who is present and your name was not called or you came in late?
Yes.
What's your name?
Joshua Mackey.
All right. Do you know your case number or SIT number? Who's your attorney? Kelly Piddle? Okay. Have you had contact with him?
Yes.
All right. Anyone else who came in later, your name was not called? All right, everybody, it's Thursday. We hope for rain. We have rain, then we complain about rain. These are the rules. If you follow them, perhaps you will make it out in time because before there's another heavy downpour, which my understanding there will be. So, attorneys, if you follow these rules, things will run smoothly. Criminal trial division files are there. Family violence files are there. Just grab one, place it on their desk. Criminal trial division attorneys are here. Family violence attorneys are there. Just put it on their desk, have a seat. They're going to call you in the order of appearance. If you have a client who's in custody, yes, they need to be brought out. Just approach the deputy, ask them to bring your client out. Once you request your client, please do not leave the courtroom because for security reasons, there are limited another number of inmates that are allowed in the box. If your client wishes to speak to the court in a language other than English, we will need an interpreter. So you will need to ask the clerk to have an interpreter call down. Once you have conferred with your client and conferred with the state, and if you're ready to approach, just approach the side, ask the clerk or the coordinator to pull your file. Hi, have a seat, and then I will call you in the order of appearance. The only exception to that rule is if your client needs an interpreter. The other thing, everybody ignores that sign there. When we're on the record, do not approach this side. Don't approach to say, hey, pull my file, or I'm just up here for 2 minutes. Do not approach when we're on the record. You'll know we're on the record because I will have called the style of the case. Do not, I repeat, do not talk behind the court reporter. I say this all the time. People ignore it, then we have to stop. When we're on the record, I will have called the style of the case. If you have a client who is behind the court reporter in the box, all you have to do is raise your hand. The deputy will come over. They will move you to the other end and you can continue to confer with your client. Do not talk behind the court reporter. Do not put your items on the court reporter's desk. Do not surround her because that makes it sort of claustrophobic. The probation officer is to the back. Probation, if you raise your hand. If you have a client who's on probation, if you have reached agreement with the state where your client, if I follow the agreement, is going to receive probation, let the probation officer know and give them, the plea deal. That will make it easier for them to fill out their paperwork. Because as you know, with Odyssey, sometimes people don't ask the people who are going to be working with the system what would make it easier for them. So now they have more steps that they need to put in the computer, and it will make things flow so much better if you will just let probation know. Today is Thursday. We call it Friday Eve. So let's have a great time. Smile, confer with kindness in your heart, and everything is going to work out beautifully. Be patient. And for all of those in the gallery, if you don't see your attorneys here by 9:45, you have my permission to step out in the hallway to call them, because guess what? We're recessing at 12. So attorneys don't rush the court at 11:45. All right, let's confer. Thank you. All right, who walked in late? Are you all just in the gallery or are you on the docket? Do you have a case pending in this court? If you do, what's your name? Okay, all right, so your brother has a case? Are they in custody?
Yes.
All right, so y'all need to move this way. And this is what I want to remind everybody. You are not allowed to wave and speak to inmates in the box. This is not the family reunion time. If you want to talk to them, then you will have to visit them at the jail. When people start talking to the inmates, guess what? The deputies start getting a little jumpy. And if you talk to an inmate, you're going to be asked to leave the courtroom. All right. So is there anybody over here who has someone? I'm going to get you guys a seat just a second. Anybody over here who has someone that they're here to see who's an inmate? If you do not, raise your hand. Anybody over here, do you have someone who is an inmate?
Okay, we're all together.
All right. Who over here does not have someone that they've come to see today that's an inmate? Raise your hand. All right, move over here. All right, yes, please move over here so they can have room. And everyone, I just do this for security reasons at the request of the deputies. Thank you.
Is it? No, what was right? No, it's awesome.
Hello? Yes.
Go ahead.
Okay, I'm just waiting for the files and I'll put it.
Oh, okay. Okay.
Norma,
Yes, ma'am.
who was the person that Laura Leflin had?
It's on the lawsuit, Judge. I'm trying to get a hold of Mr. McLean. Because I guess it was set for today.
No, it's supposed to be a case with her where he's already applied for PTD or something. It's Lauren Laughlin's
Oh,
fault.
sorry.
No.
Sorry. Yeah. Give me 1 second.
Is there someone here for attorney Lauren Laughlin? I'm sorry, Laura Leflin?
Let me text her. Her case and the-
Because she's not going to be here.
I didn't. Thanks. Did you get anything?
What's that?
You want to go get it? I need to try to find. I'll find it. I'll find about it.
Yeah.
No, it was a good deal here.
Your, number.
Let me call you.
Yes.
I'm gonna call Diane to get it.
You can put them right here, and I'll put them in alphabetical.
All right, Lucianne Miranda. Phyllis Bill. Hi. Have you had a chance to confer with the state on the violation report?
Actually, I didn't know I needed to confer with the state about the
Yes.
violation report. Okay.
Okay. Excuse me, could you hand that to Ms. Bill? And then if you'll bring that back, that's my only copy.
Okay.
That's for you, sorry. That's it. I put a.
Juan Carlos Rios.
Morning, Your Honor.
Good morning. Thank you for addressing appropriately for court. All right, so today is the day for the state to tender an offer.
Judge, I know that Mr. Holster spoke, I believe, to David Lunan at one point in the last week or two. I don't know if I exactly have that timing right.
A couple of days ago.
Okay, there
Okay.
you go, thank you.
Yes.
I don't think that we're gonna be able to resolve this with a plea offer, so.
No, I mean, has an offer been tendered? Because today was the day an offer was supposed to be
It
tendered.
was sort of a tentative offer, tentative, no hard offer has been tendered.
All right,
I'm
so,
not even sure what charge we're gonna proceed to trial.
all right, so are you speaking with Mr. Lunan about an offer?
Nope, you referred me back to this court to get an answer
An answer for what?
on what the charges were going to be, how the case was going to be handled. And my understanding right now is that we could proceed under criminally negligent homicide, or it might be a lesser when we go to trial. And we would proceed under the intox manslaughter, but I don't have a hard offer. And like I said, I'm not 100% at this point what charge we would actually go to trial.
All right, so I'm assuming, I'm assuming you all will be proceeding on what's in the indictment, and then of course, if there are lessers requested in the charge, then I guess there will be lessers requested.
Yes, Judge.
All right, so,
Because there's some discussion that they might recharge. That's all.
okay. So then, today is the day, because this has been on since March.
Judge, I can make an offer, it's just, we have been in contact with defense, I think that any offer we make is likely gonna be rejected, so if it's.
No, I mean, so today is just the day. There's supposed to be an offer made, and I'm supposed to have a trial court, I'm sorry, an acknowledgement of discovery.
Again, I can make an offer, Judge.
Okay, all right, and then after the offer is made, I'll give you a plea deadline date. So once the offer is tendered, I need the acknowledgement of discovery. And sir, how old are you?
Done one.
It's not one in the
Judge
file.
asked us for it twice.
Sorry, I'll plan to get it.
Yeah.
For some reason, it's not in the file. Yeah.
Get another one done.
Okay. So Ms. Ferguson, how old are you, sir?
56.
All right, Ms. Ferguson, set this for a plea deadline date, the week of July 15th.
He feels younger than he is. He was.
Okay, that's okay. Well, he doesn't look his age, so that's a good thing. It doesn't matter how old you are. You know, if you don't look your age, that's great.
I look older than my age now.
Well, are we gonna tell our ages now?
I can do July 16th.
All right, so we're gonna come back on July 16th. And let me just tell you, the reason why I ask people's ages is because sometimes I have people before me and they're very young, and I know they need time to process what the consequences if they decide to enter a plea is gonna be. And sometimes they want to speak to their parents or whomever guardian they have. So that's why I always ask. So I think you'll be able to make your decision. All right, so July 16th is going to be a plea deadline date. Once you sign the reset form, you excuse, and counsel, if you'll stay so that you can sign the acknowledgement of discovery. And then if nothing is reached by July 16th, your next date will be a jury trial date. All right, thank you. You're welcome.
Randy Berg.
Judge,
Yes.
I just wanted to double check for sure, even the disabilities that in here, that you're here.
Ah, all right. Where is he? Holscher. She said it's been scanned in Odyssey.
Oh, okay.
Yeah, so you're good to go.
We did do the acknowledgement?
Yes.
All right. I told you. I felt it.
You felt it, but see, you were not 100% sure because I kept asking. I'm sorry, can I have that file back? Thank you. I will make sure I put everything in Odyssey.
He's gonna be coming in soon.
If you're all.
Yeah, I sent it to him. I sent it to him, same way it was last time.
Andrew Ford.
All right, he hasn't signed in, logged into Zoom yet.
Okay.
Madam Pro Chairman,
Yes.
we have confirmed.
All right, just give me one moment. Let me log into Odyssey.
So is Odyssey working better now?
No,
I
you know,
got,
I think it's gonna take a while.
I got yelled at because I filed a motion for continuance because I was called to trial here. If they looked up the case at another county, they said, well, you're not even the attorney of record, Mr. Holster, so you need to appear. I swear I'm the lawyer on the case.
Oh, hey. Well, your attorney will say, I mean, your client will say, what? He's my attorney.
Lorraine Ekman was surprised. Yeah. That was Monday, by the way.
Oh, wow. All right. Are you all ready on Lucienne, the state, on Lucienne Miranda? It's a violation report. All right, just give us one moment. Phyllis, time when he comes back, just tap him on his shoulder and I'll take you up. Time when he comes back, just tap him on his shoulder and I'll take you up. All right, thank you. All right, the party's on Lucienne Miranda.
Slightly.
Oh, it's the arrow man.
All right. Good morning. Thank you for dressing appropriately for court. All right, court is calling night mag number 749936, State of Texas versus Lucienne Miranda. Can I have parties announced for the record for the state?
Andrew Harris Adler.
Phyllis Beal for the defense.
And are you Miss Miranda?
Yes, ma'am.
All right, we're here on a violation report. State, have you had a chance to review the violation report?
Yes, Your Honor.
All right, defense, what's going on here?
So, Your Honor, I honestly don't exactly know what's going on, except that I can tell you that starting on the 12th of this month, she has started with AA meetings. She has actually had 3 sponsors here who are willing to speak on her behalf if that's necessary. Here are the things.
Any objections to the court viewing this, counsel?
No objection, Your
And also, oh, I'm sorry, there's only 2 sponsors here.
Okay,
I misstated that.
no problem.
And she has gone every day since the 12th of June. So even though I don't know exactly what's going on, I do know that she's clearly addressing the problem and is working very hard to deal with some of the issues that have been presented.
All right, state, what are you requesting?
In the proposed order, the first option
Mhm.
with the addition that when Ms. Lucien reports that she provide documentation of attendance at a.
Okay. All right, so Miss Miranda, you're going to have to stay vigilant about your sobriety. I know that what you're charged with is driving while intoxicated. I don't take any of that as true because nothing has been presented to me. But you're on bond, so as a part of your bond, there are certain things you have to do. You're on ignition interlock, so therefore, when it's a positive hit, it doesn't start. But if this continues, what's going to end up happening is I'm going to either have to place you in custody or either you're not going to be allowed to drive. You understand? All right, this is what the court will do. The court will follow the suggestion from the state and defense. Are you in agreement with that?
We are.
All right, I'm going to continue with ignition interlock. There's going to be weekly reporting for 60 days and drug alcohol testing. Random, the fees will be waived. And I'm going to order 90 sober meetings in 90 days. And we can go off the record, Miss Miranda, this is where you learn, and you're supposed to be learning what you need to do to maintain your sobriety. So even though I'm ordering that you do sober meetings every day, if you feel as though you need to do 2 a day or 10 a week, then do those because you must maintain your sobriety. You have children, you understand? All right. If there's anything that you need from the court to help address any sobriety issues you have, come back to the court with your attorney before I get one of these reports. You understand? All right. Is there anything else you need? All right. Good luck to you.
Thank you.
Thank you.
Judge.
You're welcome. And Ms. Bill, if you need a copy of the order, they can give you a copy of it in back.
Okay,
All
thank
right,
you.
you're excused. Thank you.
Thank you, Your Honor.
Jose Maria Cavazos. Are they going to be by Zoom?
I'm not sure.
Yes. He's gonna be by some.
All right, so I'm just waiting for them to zoom in. You know, if it wouldn't take Odyssey so long to upload, I'm watching the circle go round and round.
Yeah. No, the warrant status on here are not, they're not red.
A little bit. She's smiling. She's. You don't file for.
Your probation magistrate. If you'd be convicted, then you would be convicted.
Okay, Deputy Laura. A hiker was in the mountains, Sierra Nevada mountains. She goes, it's snow in June. I guess it's always snow because of the elevation. She goes to get water. She is bit by what she assumes to be a spider. See, probation turns to me because now, yeah, maybe she's a hiker. So she is able to make it back to her encampment and is paralyzed from the bite. As her cell phone is dying, she's able to call for help. And they finally went to go get her. She's paralyzed from a spider bite. I need to know. Yes, because didn't Bashan have a fight with the spider? Maybe that spider is looking for Sean. Oh, I'm doing fine. How are you doing?
So, yeah, you pulled up.
Still, I'm kind of. This is quite. So I know when I was still on today, but I don't think it showed it. I don't, yes. Did you agree? But then it also showed that I had seen it in the It showed, I don't think we got it just beyond. I'm not sure. No, I think I don't see so what it is, I think. So I think it's fair. How did we get it? Those that one of the indictment. That's fine. That's the- it would be either intentional or second elsewhere. Yeah, there's no other code. So if that's like, and I look at it like, really word for word. It's just in the flash. So what's the? I heard the other stuff. She has that. Yeah.
Making sure.
That's fine for now, but it isn't quite.
Yeah, I have to do some, like, we have to. Now, look, we would not have some knowledge. We had a conversation about, that you have actually sounds. Of course, you have one.
Yeah, this is. But it has its relation to where it justifies its issues. This one's the. So right,
Say that he violated. Short. Even with their personal stuff.
short. No, I think it was, well, and if this was graded, or if Greg has one, we should just try to look at that. I think it's fine. Come down with this stuff, especially these are the movies. But you saw what I saw in my. Something.
Yeah.
It kind of throws things on.
Okay, sounds good. Well, let me go ahead and speak to Richard about.
Sounds good.
And then, I'll just, tell the other client, we start that. Comparison. Absolutely.
I'm glad we talked about this, Greg.
And part of it was with my complaint, because both my case and his.
No, I'm glad we're meeting now, because that is extremely.
Yeah. Something, I'll let you know.
Yes, that's correct. What's going on? So. It's also. Violation. Tell us. It's very fair. Zero. Right, 2 years sentence in the past, something that she probably just got back. So, no work. Yeah. I mean, I know. I hear you. I really, I genuinely. She is, yes. I don't want to speak for her because I think it's unlikely that she's currently. I don't know the nature of this. There is a series of. I think that's what I'm saying.
One zero zero.
I can look on.
Oh, and Mr. McLean, is your client by Zoom? All right, he hasn't zoomed in yet.
Just called me and they were trying to get it set up and on there now, so I'm hoping he's gonna be on any minute.
All right, as soon as he zooms in, I'll call you up. Thank you.
Don't communicate with anybody or be asked to step outside.
All right, to the inmates in the box. If you communicate with somebody in the gallery, guess what's going to end up happening? You're gonna, one, they're going to be excused from this courtroom and they are not going to be allowed back in this courtroom. And two, we may send you back to the Bexar County Jail as a form of punishment. Does everybody understand? All right, thank you.
Judge, can we send you an email?
All right, thank you.
Yeah.
All right, let me see the file on Alfonso Diaz, please. All right, is he in custody? Deputy Laura, when you have a chance, could you have them bring out Diaz just briefly? It's Alfonso Ruben Diaz. Thank you. Who's here on Jose Gonzalez? Are you all ready to proceed?
Yes, sir.
All right, who's on for the state? Mr. Gonzalez, if you'll come down. Court is calling 2023 CR 6424, State of Texas versus Jose Gonzalez Jr. Could I have parties announced for the record for the state?
Andrew Harris, Salem.
Defense,
David Rodriguez for Jose Gonzalez Jr.
are you Mr. Gonzalez?
Yes, Your Honor.
Did you review the document entitled Motion to Revoke Community Supervision and First Amendment Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Jose Gonzalez Jr. who was placed on community supervision in 2023 CR 6424 for the offense of unauthorized use of a vehicle on September 29th, 2023 for a term of 2 years? Is that you?
Yes, Your Honor.
State, which allegations are you proceeding on?
I believe it is violation of condition number 4, Your Honor, failure to report.
All right. The state is alleging that in Bexar County, Texas, the defendant Jose Gonzalez Jr. did then and there fail to report to the supervision officer as directed for the months of November and December 2023 in violation of condition number 4. to that violation, how do you plead? True or not true?
Sure.
There are two number fours. Are you proceeding on the amended as well?
No, Your Honor.
All right. And with regards to the other violations, state, do you waive those violations? Any objection?
No objection, Your Honor.
All right, Mr. Gonzalez, did you understand by pleading true to violation of condition number 4, court could find it true, grant the motion and sentence you up to 2 years in the state jail facility and up to a $1,500 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, Your Honor.
Court will find violation of condition number 4 true. Could y'all please not talk behind the court reporter while we're on the record? All right, the court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor.
And what is the proposed agreement?
Supervision that says punishment and confinement of 6 months, Your Honor. And state will take into consideration and dismiss grand jury number 822-304.
I'm sorry, 822.
304,
And what is that alleged offense?
possession of controlled substance PG to less than a gram.
All right, and probation?
Your Honor, probation is recommending treatment with our substance abuse treatment facility that would provide the probationer treatment and education in his thinking errors related to his substance abuse and will help probationer identify underlying factors of the ongoing use of substance abuse. His last report date was October 4th of 2023. We did make attempts to call him by phone and email. He has his last drug test, I believe, it's showing October 16th of 2023, positive for marijuana. He has not made any payment towards probation, and he has not completed any programs that were ordered, the TAP parenting class. And he is I'm seeing he was ordered a gang evaluation and it's showing incomplete.
All right. So I'm not going to give you 6 months. That's the minimum. You have done nothing. What have you done while you've been on probation to deserve the minimum?
No, I was doing the
All
parenting
right, you're going to
classes.
raise your right hand for me. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your
All right, you can lower your hand, state your name for the record.
Jose Gonzalez.
All right, what would you like to say?
Yeah, I was doing the parenting classes, but I didn't finish it because I got fired. Oh, I got unemployed, and then my wife kicked me out into the streets, so I was homeless and I didn't have nowhere to go. So I had no job, no money, no nothing.
All right, so you're telling me your wife, who obviously loved you to take you back in, even though you had criminal charges,
No,
she put you out because you were
she
unemployed.
she was her boyfriend. Her boyfriend didn't want me to stay there.
Oh, well, I understand that. I mean, she
Yeah,
has a
that's why-
boyfriend, but she's letting you live there too?
Exactly. That's why she kicked me out the street because her boyfriend didn't want me to stay there with her.
Okay, I mean, I hope you understand that.
But I had to be staying there because I was on probation and that's where my address was.
But you understand why, if she's in the relationship with somebody else,
Yeah,
why?
she said I could stay there with her. And then when I got out, she wanted to mess up my probation, so she knew I didn't have nowhere to stay, so she knew I'll go to the streets and I had
All
nowhere
you had
else.
to do was come back to court and say, I have no place to stay.
You know, I didn't have no court date at that
No,
time.
I tell everyone, if there's an issue with probation and you cannot get in touch with probation, we are here Monday through Friday, except on holidays and weekends. And I know I told you, all you had to do was come into court and say, Judge, I just been kicked out. And if you would have told me that was your living situation, I would have told you, I don't see how that's going to work.
I wasn't thinking, she had told me I could go stay with her, but her boyfriend, I didn't know she had a boyfriend. She said she was single.
Well, I think that would have been a very uncomfortable situation.
Yeah, I would not said that I could go stay with her, but She liked me, so it was settled. She set me up for failure.
Well, no, you're an
Yeah,
adult.
because
You should have known.
I didn't know she had a boyfriend,
Okay,
and she didn't want me there, so she said if I don't leave, she'd call the cops.
all right.
So I left, and she knew I didn't have nowhere to stay.
You should have left and went straight to probation.
I didn't have a phone or nothing.
You should have left. You should have caught the VA bus and went straight to probation, or either came straight downtown to this
I
courthouse.
wasn't thinking, I was,
All right, so here's the thing. The bottom line is, I don't think 6 months is an appropriate sentence for you because you have not completed anything.
yeah, well, she kicked me out the first month. I didn't get to complete nothing, but I was going to parenting classes.
Mhm.
That's it.
Okay, I understand. How old are you?
I'm 36. I'll be 35.
All right, so I don't think 6 months is an appropriate sentence. I'm gonna give you a choice. I'm looking at the motion to revoke. And I'm looking at the allegations that are in the motion to revoke. You have done nothing. Here's your choice. You can either go to the state jail facility for a year, or you're going to inpatient treatment. Those are your choices.
I'm going inpatient treatment now.
All right. This is what the court, and that's what you all are recommending, inpatient, correct?
Yes, Your Honor.
All right, the court is going to find violation of condition number 4 true. Court is going to deny the motion, alter and amend conditions, to include the MRT and probation. Are you recommending SATA or safety?
SATA, Your Honor.
There's going to be SATA, and he's to remain in custody until transfer. We can do a referral to felony drug court as well. I don't know if they're going to accept him because I don't know if he's a gang member or not. You got to be extended for 1 year. And taking consideration grand jury number 822304. And the reason why I am following your agreement to take that into consideration is because they won't transfer him to any type of inpatient program or anywhere unless that case is no longer there. All right, is there anything else you need from the court?
No, no.
All right, we can go off the record. State your excuse.
Thank you, Your Honor.
Here's the thing. I am here Monday through Friday. If for some reason, for medical issues, I'm not here, there's still the coordinator or another judge who will be here. Probation will be here. You can always come in and tell them the issues you're having. But what I will tell you, the only thing that you've successfully done since I last saw you is obtain more tattoos, which I have no problem with people having tattoos, but it's not good for employment because people are going to look at your tattoos.
And self-employed, like I could build houses, so I get my own jobs.
All right, so here's the thing, my advice to you, you can take it or not take it. Stop with all the facial tattoos unless you're planning to be a rapper, you're planning to work in the entertainment industry. And even then, sometimes they're going to want you to put on foundation to cover it all up. But you're walking into a business with that, people will see it and make certain assumptions. Me, I see it all the time, so I'm always interested in the different tattoos. All right, so you're writing a mustache in?
So when I grow it, it can
Okay.
be
All right.
complete.
All right, good luck to you.
Thank you.
And everyone, just one moment. Oh, and I'm sorry, probation with regards to Mr. Jose Gonzalez. All right, when he's released, I'm gonna order 120 sober meetings and 120 days. The UA hotline until further notice, and field visits until further notice. All right, on Cristobal Gomez. All right.
I think today was the deadline for plea, Judge.
Yes.
We've conferred with the state. I've conferred with my client. At this point, we do not have a meeting of the minds.
All right, so Mr. Cristobal, I'm sorry, Mr. Gomez, your plea deadline date has expired. The court will not consider any plea bargain agreements without good cause. Otherwise, you'll have to plead open to the court. Do you understand?
I was gonna ask you, ma'am, if I can drop it down a little bit. I mean, I'll sign
No,
that.
no, no. Here's the thing.
Yeah.
And I want to tell you some rules because sometimes I know that people don't know the rules and especially the legal rules, right?
Yes, ma'am.
These are the legal rules. I am not a part of your plea negotiations with the state.
Okay.
What ends up happening is the state will tender an offer. Once they tender an offer, your attorney is ethically bound to tender that offer to you.
Mhm.
You have a choice. You can either accept it or reject it. Sometimes you can make what's called a counter offer. And what a counter offer is, if you tell your attorney, I won't accept A, but I will accept B, then your attorney is ethically bound to go to the state and say, my client will not accept A, my client will accept B. You understand?
Yeah.
But I am not a part of your plea negotiations.
But I never had an A or a B.
Oh, well, here's the thing. When I say A or B, I'm going to ask you some questions. I don't want to know what the offer was to you. Did your attorney come to you and tell you this is what the state is offering you? Yes or no?
Yes, ma'am.
All right, that's an A.
Okay.
All right. Did you tell your attorney you did not want to accept what the state was offering?
Yes, ma'am.
Did you tell your attorney what you would accept from the state?
No.
No. You haven't told him what you would be willing to accept?
Well, I had to ask him.
No, 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 no. Yes or no? Because I'm not trying.
I haven't.
So you haven't told him that you would be willing to accept a different offer?
No, I have not.
All right.
I've conferred with the state judge. There's no wiggle room. So at this point,
All right. So what your attorney is telling the court is that the offer that you want from the state, there is no need for him to go to the state with that because the state is saying they are not going to go below whatever they offered. Do you understand?
Yes, ma'am.
So Do you want to, you understand that?
Yes, ma'am.
Have you internalized it?
Yeah, no, I got you.
All right.
Thank you.
So is there anything you don't understand?
No, I understand everything. now.
Right,
Thank you.
so whatever the state offered you, they're saying they're not going below that. Is that correct?
Yes, Judge.
All right. So then what I need to know from you is whether or not you're entering into an agreement with the state or not.
No,
All right. So you want a jury trial? That's where we are.
I'm not-
Well, I mean, if the state is not going to give you what you want, then and you're not going to accept what they're offering, then the next step is a jury trial, okay?
Okay.
All right, how long do we all expect this trial to last?
2 to 3 days. It's not gonna be a long one.
All right, Ms. Ferguson, I need a jury trial date on Cristobal Gomez. Thank you. And she's gonna give me a date. That will be your jury trial date. Counsel, if there's an issue with this clothing exchange, just let the court know. You're gonna be brought over to court for trial in whatever clothing you were arrested in. If you wish to be attired or dressed in something different, you'll need to do a clothing exchange with your attorney. If your attorney is having some sort of issue with the clothing exchange, they'll let the court know and we'll see what we can do to expedite it.
We'll get him close, Judge.
All right, thank you. All right, your jury trial date is going to be August 6th.
Thank you, Judge.
All right, thank you. And counsel, have you all already done an acknowledgement of discovery?
I'm not sure. No.
All right, if you all do an acknowledgement of discovery before you leave. All right, thank you. And Norma, on this one, I'm just waiting for them to tender an acknowledgement of discovery. And you say it's Alfonso Diaz? Yeah. Alfonso Diaz, come down, please. And Norma, on this one, we'll reset it for 2 weeks.
Oh, it's the arrow.
Mr. Diaz,
This one.
your attorney had a medical emergency, so we're gonna recall you back in 2 weeks.
All right.
All right, what date, Ms. Ferguson? All right, so we'll bring you back on July 8th. If for some reason, your attorney is able to come in before then, he'll let us know and we'll put you on the docket sooner.
All right.
All right, thank you.
Yeah. Second chair.
Matthew Rendon? All right, where are we on this case?
Judge State did make an offer today.
Okay. All right, how old are you?
I'm 24.
All right, Miss Ferguson, On this case, set it for 1 month for a plea deadline date.
Judge, can I advise the court, there's multiple defendants in this case, and
Yes.
it seems like we're not getting on the same docket, is that?
Oh, no, they're gonna be on the same docket. So don't worry about that.
Okay.
I'm sorry, when?
July 25th.
All right, July 25th is gonna be your plea deadline date. Once you sign the reset form, you're excused. You're welcome.
You can have a seat, sir.
And Raymond, you can make sure that you sign the acknowledgement of discovery if one hasn't been done. And state if you'll prepare the acknowledgement of discovery on Matthew Rendon. All right, thank you. All right, are the parties ready on Jose Cavazos?
Yes.
All right. Yes. I think this is your person, JC 316. All right, JC 316. Is this your person?
I've never seen him. Are you Jose Cavazos? He's got to connect to audio.
Okay, yes.
Connect to audio.
Oh, it's connecting. It's just taking a while.
Not us, Judge.
Oh, no, it's them. All right, it's connecting. All right, let's do this. They're slowly working on connecting. As soon as it's connected, I'll call you all back up. So I won't leave until he's connected. James Brandenburg, yes, come forward. And then McLean, they're connected. Just give me a second. All right, where are we on this case, counsel?
Judge, I got an offer today, communicated it to my client. We need some time to think about it.
All right, sir, how old are you? All right, Ms. Ferguson, if you'll call this in 3 weeks for a plea deadline date, it is Brandy Berg.
Thank you, Judge.
Okay. And if y'all could do an acknowledgement of discovery, please.
Yes, Your Honor.
No problem.
That would be July 11th.
All right, we'll come back on July 11th. On July 11th, you need to let the court know whether or not you're accepting the state's offer. You understand?
Yes, ma'am. Thank you,
All
Your
right,
Honor.
thank you.
Okay, I got it written down. I'll be in touch, sir.
All right, and if you all will come back up and just give me a moment. I have to put everything in Odyssey now. And the system runs very slow.
Take the vote there for that.
It's getting better.
Yeah, it's like, he's got a space, but I'm not back here. I know. right?
Are you looking around? Thank you.
right, Mr. Cavazos, if you can unmute.
Unmute.
Yes.
All right, thank you. All right, so counsel, where are we on this case?
Your Honor, this morning is a final hearing on this case. This has been a long time coming.
Yes.
We've been working on this case for a couple of years now, trying to get everything kind of positioned so that we can finally do this. We've finally gotten the lab report back, and so today is our hearing under 64.04 of the Texas Code of Criminal Procedure. And so I've conferred with Ms. Moore. We've got a couple of exhibits that we would like to tell her what should get going on the record, and then we can just have a quick final hearing.
All right,
Is this okay if I'm back here?
oh, yes, that's fine. Just give me a moment. All right, let me just find your motion. It even gave me a temporary file because it went missing. Just 1 second. Thank you.
Report to the see if I'm judging.
All right, do you have a copy of yours?
I don't have a hard copy. I can send it to you. Will it email it to you? Or-
You don't have to be in now.
Yes.
You got it.
Okay. And I'm still looking to see if I have the file. I mean, I have the only motion I have in here so far is the motion for DNA testing. That's it.
That would be the motion. And so what happens after that is that they actually go and the court granted that motion way back. I think it was.
Yeah. So has the DNA testing been done?
DNA testing has been done. And so the court actually did the analysis under 64.03.
Okay.
And so now we have to do the final hearing to determine whether or not the evidence that came back would have exactly what the language is.
The exact words are, had the results been available during the time of the offense, it is reasonably probable the person would or would not have been convicted.
Okay.
That's
And see, I'm just trying to find that in here. Those words, because I don't see that. The only thing I see is we're requesting DNA testing. That's all the motion said. So the DNA testing was done and I'm reading the motion. And
But I can give you kind of just a factual,
Sure.
historical update.
all right, let's go on the record. Court is calling 2010 CR 5796, State of Texas versus Jose Maria Cavazos for the state
Foreign somewhat for the state.
defense.
David McLean from the petitioner.
All right, and state you may proceed.
Yes, Your Honor, and before we begin, I just would ask the court to take judicial notice of the court's file, all the pleadings on file, including the plea bargain agreement, stipulations to evidence. We'd ask the court to take judicial notice of all of that.
Any objection?
No objection, Chair.
Okay. So just for a brief background, Your Honor, this is involving a case where there was a plea to 1 count of aggravated sexual assault of a child on August 5th of 2011. Mr. Cavazos was sentenced to 15 years confinement. We are now here on the Chapter 64 motion that was filed by Mr. McLean on behalf of his client. The court granted his testing. The testing has been completed. And so we are now here on the final hearing after the testing has been completed. I will tell the court, just for background knowledge, there was some DNA testing done during the time of the investigation, prior to the plea bargain agreement. and I don't know how much factual, if we want to get into this now or not, but I can.
Go ahead.
So at the time, Your Honor, before the plea, there were several items given by the complainant's mother to law enforcement. Just for a little bit of factual knowledge, the allegations are that a 4-year-old complainant was spending the Thanksgiving holiday with her grandmother.
Right, and just one moment, sorry to interrupt.
Sure.
By Zoom, we have your client. Is there any objection to Mr. Cavazos appearing by Zoom? State?
No objection.
No
Defense?
objection.
Mr. Cavazos, do you have any objection to appearing by Zoom?
No, ma'am. No, ma'am.
All right, you may continue.
Thank you, Judge. 4-year-old, the complainant made an outcry that during that Thanksgiving break, Mr. Cavazos sexually assaulted her. There were 4 counts in the indictment. Mr. Cavazos pled to 1 count. During that investigation, because the mother did not exactly know which clothes the child was wearing when she was sent over to her grandmother's house, she gave law enforcement 6 pairs of blue jeans, 8 shirts, 2 shorts, 3 socks, and 4 pairs of panties. At that time, 2 pairs of the child's underwear were tested. There was no DNA, there was no semen or blood found on the DNA. So there was, the only thing at the time was the child's, I guess, outcry. So there was no DNA as part of the plea. Once once you granted DNA, some of these items were tested. 2 of those blue jeans were tested. There was 2 cuttings out of those blue jeans. That was what was tested. That's what we have the results on today, Your Honor. And so that's kind of where we are today.
All right, and with the regards to the blue jeans being tested, is there an agreement on what the results are?
Yes, Your Honor.
Yes.
All right, and what are those results?
Judge, if I may, to submit to the court, I'm going to submit first Petitioner's Exhibit 1. This is the forensic serology report from Bexar County Criminal Investigation Laboratory. This is dated January 6, 2010. This is the list of the items that were originally submitted for testing. And as was previously identified by Ms. Mora, the only things that were tested revealed no semen, no blood, and no matching DNA to my client.
All right, so any objections to Petitioner's Exhibit 1?
No objection.
Then Petitioner's Exhibit 1 will be admitted without objection.
Second thing we're going to admit is Petitioner's Exhibit 2, which is the Forensic Advantage Discovery Packet. This was dated March 7th of 2024. This has been previously tendered to the state for review. This is the results from the Bexar County Criminal Investigation Laboratory. I'm going to I kind of dog-eared it for the court for easy reference, but it shows that the same unknown individual was identified in cutting number 1 from the blue jeans and cutting number 2 from the blue jeans. And
Oh, sorry, if you'll just slow down for the court reporter.
I'm sorry. And Jose Marie Cavazos is excluded as a source of this unknown genetic profile. And so I would submit Petitioner's Exhibit 2 to the court.
Any objection to Petitioner's Exhibit 2?
No objection.
All right, then Petitioner's Exhibit number 2 is admitted without objection.
Judge, I have just from the state, we don't have any agreements in this case. The state is opposing any sort. We would be asking the court to find that if the result had been available, he still would have been convicted under his plea. These cuttings, as you look at the report, I'm sure the court will review them. It shows that there was an unknown female profile found on those cuttings. So of course, his client would not match an unknown female profile. Additionally, Your Honor, those 2 cuttings really didn't have enough evidence of anything on there to do the YSTR chromosome testing that the applicant was requesting. So there was nothing, they weren't able to get a conclusion. So what we have here is essentially he is excluded as an unknown female contributor on the genes. So for those reasons, Your Honor, we're asking the court to find that had those results been available, it's reasonably probable that that he would have been convicted. There was no DNA at the time of the plea. There's still no DNA. It doesn't change the position that we're in. So we would ask you to find that those results are unfavorable and that wouldn't change the outcome of the case.
All right, defense.
Judge, I was appointed on this case quite some time ago, and since then, we've had the opportunity to try and get the DNA testing done that was not done in this case. From my client, from Mr. Cavazos's perspective, that was pretty important because the DNA testing, as Ms. Zamora stated, the evidence that they had at the time of this plea was, hey, we don't have any DNA matching you, but we've got all these other items that were never tested, and they're going to come back and they can show that you're the contributor.
Yes, you can.
Mr. Cavazos, from my conversations with him, entered into a plea with basically that big unknown hanging over his head. And we think that because what we submitted when we asked to get this tested was to have all those items that were in Petitioner's Exhibit 1 tested for DNA. Everything that got tested was those 2 blue gene cuttings. So we can only assume there was no DNA on anything else. And so what we're telling the court is, had that information been available to Ms. Cavazos at the time, then Mr. Cavazos would not have entered into this plea bargain and would have decided to go to trial instead. And having no DNA matching him and only having a outcry from a 4-year-old, that would have changed the outcome of this trial. I think a jury very likely would reasonably have said, no, with results excluding Mr. Cavazos, would have said, no, Mr. Cavazos is not guilty. And so our position is that it would have changed the outcome of this trial. And the language, again, is the court is to determine, I'm sorry, I'm in the wrong section.
Well, here's my question. Would it have changed the outcome of the trial, or would it have just changed whether or not your client entered a plea?
And that's the question. Had the results been available during the trial of the offense? Because my client, and I can call him if Mr. Cavazos wants to testify. His information to me is, I would not have entered this plea had I known this information.
Right.
And so then we would have had a trial. And if those results had been available during the trial of this offense, it's reasonably probable that he would not have been convicted.
All right,
because
so-
it conflicts with what the outcry statement.
All right, so the court's focus, and correct me if I'm wrong, the court's focus is not whether or not he would have entered a plea. It's whether or not the outcome of a trial would have been different if a trial would have taken place. Is that correct?
Yeah, I think one thing needs to be clear, Judge, Chapter 64 is not a vehicle for relief. That would be a writ. So if you were to find that this is a favorable finding, then he could take that evidence and file a writ and then challenge his conviction that way. So we're simply here today on a Chapter 64 to determine whether or not this evidence that was tested was either favorable or not favorable. And I'll give you the exact language. And if that evidence that you've seen now was available during the time of the offense, it is reasonably probable that the person would or would not have been convicted. So what, and at least in my opinion, he's giving you is an exclusion of Mr. Cavazos of a female contributor. That's all. So is that favorable or not? And would that, if that had been available, would he or would not have been convicted? It's kind of hard because we have a limited record on the plea, but this does not keep him from filing a writ later on,
Okay.
on either an ineffective or whatever he wants to do.
But I just want Mr. Cavazos to know the court's focus is not on whether or not he would have accepted a plea or not a plea. It's whether or not would there have been a favorable outcome at trial.
I completely agree.
So I just want you to know that, Mr. Cavazos. So the issue is not whether or not you would have accepted a plea or not accepted a plea. Under the law, I'm just here to make a decision about potentially whether there would have been a favorable outcome at trial. Do you understand?
Yes, ma'am.
All right. All right. So what we'll do, I'm sorry.
I have a question.
Yes, you can ask your question.
Okay, the attorney that I had that was representing me during the court time told me that I had to sign the plea.
Oh, no,
because-
Mr. Cavazos, let me just explain to you. One, if there's something you want to say that your attorney said that is for another hearing. That is not specifically for this hearing. And you probably should talk to your current attorney before you do that.
Okay,
Okay?
okay.
All right. So for both parties, if you want to submit a brief to the court, you're more than welcome to do that.
Okay.
If you all don't want to submit a brief to the court, then I will read petitioners 1 and 2 and make a decision.
Sounds good.
All right.
Do that.
Y'all want to submit a brief?
I'll submit a brief, Judge.
All right. So how much time do you want?
Given that I have like 3 appeals going right now.
Oh, no, just let me know.
If I could have 30 days.
All right.
Does that work?
Ms. Ferguson, on Cavazos, if we'll recall this in 45 days.
That'd be great, Judge. Thank you.
All right.
And I'll file an amended state's answer. for the
All right.
court to consider.
So,
It won't be long, but
all right. So what date?
You do it August 8th, Judge.
All right. So your briefs will be due on August 8th. And then, Ms. Ferguson, let's set this for 2 days thereafter. And then we'll have another hearing and I'll give you my ruling.
Yes, Judge.
August 13th.
All right, so then you all will come back on August 13th.
which is a Tuesday. Can I get any other
Yes.
day?
All right, any day other than Tuesday, Ms. Ferguson.
That'd be perfect. Thank you.
All right, so we'll do it August 15th. And counsels, if for any reason you're not prepared on your brief by that day, just let the court know so that we won't have him by Zoom. All right, so Mr. Cavazos, tentatively, what's going to happen is on August 8th, both the state and your counsel will submit briefs to the court for me to review. And then we'll come back on August 15th. And on August 15th, I'll make my ruling. Do you understand?
Okay, okay.
All right.
So,
All right, we're off the record. Counsel, we all know what's happening with Odyssey.
Oh, yes.
So if you all could, I know how they want you to file it, but if you could make sure that I have a copy just in case it gets lost in the,
I've started
I'm
doing that
continuing.
more and more and more, and I will make sure you have a hard copy.
all right.
Gotta
Thank
get it.
you.
Can be excused, Your Honor.
All right, yes. Do you need to speak with your client?
No, I can call him later. I've got direct lines to him. And so Jose, I'll touch base with you after court this morning, okay? Okay,
okay.
All right, thank you.
thank you. Appreciate
Thank
it.
you. You're welcome. All right, everyone, just give me a moment and I'll take up the next case. And Norma, can you make copies of that for me? And then the exhibits to go to the court reporter.
Okay.
All right, thank you.
Right now, do you need my phone?
Excuse me. Hi, she's gonna make copies of those. Okay, awesome. I didn't want it to get lost. All right, thank you.
How many copies do you need, Judge?
Oh, just 2. Oh, Norma, you can either copy it or either if you want to email it to me, whichever is easiest. Email is fine. We'll save some trees. Yes. Yeah, for me.
Okay.
Oh, here's the rubber band.
I think it's.
Renee Camarillo.
About that motion and I
All
don't know if
right.
it came through with Odyssey.
Okay.
So I wanted you to see that. The other thing, we were just here, I think Monday, but don't hold me to that. Every day is blending together. But we got reset to go over discovery and I want to say it was August 19th and I have a vacation letter that day. I didn't realize that when we were here, if we could just push it to the 20th, maybe.
All right, is your client in custody?
Yes.
Miss Ferguson, can you remove Renee Camarillo?
Camarillo.
Camarillo, the double L's.
I know.
We'll just set it on August 20th
Thank you, Judge.
and I'll give you the phone.
Thank you, Judge.
You're welcome. All right, and just give me one moment. Let me go to Odyssey.
I think the 19th. Correct. I'm definitely positive. Okay, I was like, I'm pretty positive. That's the day I fly back, so I can't be there.
No, no. No, I won't have to bother you for that. Oh, really? Yeah. You got a whole barrel. Ready on making cruise? How you doing for Denzel, Apia, like I'm working.
You want me to take it back?
Oh, I do.
Thank you.
Christopher Weezer. Oh. Yes, there we go. All right, where are we on, who's the attorney on Christopher Weezer?
I am, Your Honor.
All right, and for the state?
Just that, this is the last name with an H? Yeah. Oh, yes, okay, sorry. Yes, Judge,
All right, where are we?
so I'm on 2 of his felony cases, Judge, the possession of controlled substance less than a gram
Mhm.
and repeated violation of bond protective order. I
Yes.
reviewed the discovery seems intact on those. However, he does have 2 assault family violence cases with attorney Greg Dismaris. He's set to appear with the court on that June 25th, so about 5 days from now, Judge.
All right,
But it's my understanding that he's gonna confirm with state's attorneys and likely reach a resolution on that date. It's just since I'm not on those assault cases, Judge, I can't advocate on.
all right, it's set for June 20th.
And I think the other cases, Judge, might be set for June 25th.
Okay.
The other 2.
No, all of it says June 20th in the file, so. Norma, when is Weezer set on his other cases?
Yes, Judge, that may have been attributable to me because I'm gonna be out next week and I had requested some of the cases to be moved, but upon looking, I saw that Mr. Desmaris was in fact on 2 of his other cases.
DeMarais, that's how he says he
DeMarais.
pronounces it.
Okay.
When we were practicing together, it was not pronounced that way.
Oh, you
So I
guys
had to-
practice together? Oh, okay.
Well, when I say practice together, he was a defense attorney, I was a defense attorney.
I have to remember that, Judge. I was kind of.
It's either now he pronounces it DeMarais or DeMarais.
I'm not sure, Judge, but please don't tell Greg I don't know.
Okay. All right, Ms. Ferguson. On Christopher Weezer. Does he have a date for June 25th? I see it all for today.
It's all up for June 20th. I want to say when I, yes.
Yes.
Christopher Weezer.
All right, I don't know why, because I have 20th in every file. All right, we're gonna come back on June 25th.
I think Renee had requested him to be brought over early.
Ah.
That's right, Your Honor. Is it all right if Mr. Demaray, comes, he said he would be here on the 25th date. And since he has the more serious offenses, I think that mine are likely gonna be TIC dismissed, Judge.
Of course.
Okay, appreciate that.
All right, thank you so much.
Thank you, Judge.
All right, thank you.
Thank you.
So play back on the 25th?
Yes. And let Greg know.
The top row.
Trevor Morse. Who's the attorney? Oh, hi.
Me again, Your Honor. Yes.
All right, so where are we on these cases, counsel?
Yes, Judge. In speaking with my clients, I think there's some significant mental health issues.
Okay.
I haven't been able to assist in his defense at this time, and I don't think he has a rational, factual understanding of the proceedings, Judge. So I wanted to see just an abundance of caution about filing for a competency evaluation.
All right, Ms. Ferguson, on this case, Morse, can you give me a 45-day reset for competency? And counsel, will you file that motion?
Yes, Judge, I'll file that today.
All right, thank you. And Mr. Morse, we're going to bring you back in 45 days. That's just to see where the evaluation is.
I can do August 5th.
Sure.
All right, so we'll come back on August 5th.
Yes, sure. Thank you.
All right, you're welcome.
Now she's gonna be a status update.
Yes, on the competency evaluation. And counsel said that he'll file the motion.
Well, there you go. That's how it happens.
That's very.
Ward,
Yes.
Randy Lee Elizondo.
Turner, I'm here on his behalf, Judge. He's not on your docket.
Yes.
Judge, we were here last Thursday and he has a competency hearing on next Thursday, the 27th. And at that time, you reset us for July the 22nd. I was gonna be out of town.
Yeah.
Got home, the boss tells me we're flying back on the 22nd.
Okay,
And I just wondered, we could call it on the 29th instead.
all right.
00042.
Yes. All right, you're welcome. All right, have a good one.
Okay.
Yes.
Sign a reset or? Yes. Thank you.
Who's here on Nathan Cruz? All right, Norma, I need a jury trial date on Nathan Cruz.
Judge, I'd like to make a record on this real quick.
Sure.
Judge, this case was originally set. for
Well,
trial.
in order to make a record, I need to call the case.
Oh, I thought you did, sorry.
No. All right, court is calling 2023 CR 9657, State of Texas versus Nathan James Cruz. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
For the defense?
Stephen Gilmore from Mr. Cruz.
Are you Mr. Cruz?
Yes, ma'am.
All right. Defense, you'd like to make a record?
Yes, Judge. This case was last set for trial on Tuesday of last week.
Yes.
We were recalled to Friday. Mr. Cruz was not transported Friday. Had this case recalled for today. I announced ready on Tuesday, would have announced ready on Friday, filed what is defendant's second assertion of his right to a speedy trial. He's been in custody as of last Friday, 312 days, was arrested when he was 17 years old. He's been in continuous confinement. We made our initial speedy trial assertion on August 9th. On August 14th, I filed a writ challenging probable cause. On August 24th, I filed a motion for examining trial. None were ever set. State indicted the case without conferring with me, though I attempted to. The state is not ready for trial. They've given me every indication that they will never be ready for trial. And so I would like the state to be asked to make an announcement on this case on the record that they are not ready for trial. So that I can continue pursuing the speedy trial rights. I can't agree to a reset of the continuance or else I waive his speedy trial rights. So I'm objecting to the reset and I'm asking the state to put their not ready announcement on the record.
All right, and just so everyone is aware, I'm only one person. I can only try one case at a time. And last week, we were in a murder trial. State.
So yes, Your Honor, we were in a murder trial. I wasn't the one that announced last Tuesday, so I don't know what they announced. At this current moment, we weren't aware that it was gonna be set for trial today. We thought it was gonna be reset for another trial date, so this case we wouldn't be ready. But if the case is reset, we would attempt to see what we can do on that.
As an officer of the court, Judge, I can tell you that ADA Garahan told me and has been telling me that the state is not ready. And it was not ready because of the murder trial. They are not ready on this case because there are necessary witnesses they don't have and they will never have. And so the state's never going to.
Well,
be
let me
ready.
stop you all right there. Ms. Ferguson, have this brought back for June 24th for trial.
Thank
There
you,
we
Judge.
go. He'll be dressed.
Thank you, Judge.
Is there anything else?
Nothing further, Your Honor. May we be excused?
Yes.
Thank you, Judge.
Well, just one moment.
Oh,
I need an acknowledgement of discovery file.
we did that, but I'll do it again if not.
All right. And Ms. Ferguson, having brought over dress for trial on Monday. Denzel Apia. Help me with that pronunciation.
Good judge.
All right, thank you.
Morning, Your Honor.
Hello, counsel, you're on this side. All right, so this was reset so you could go over discovery.
Judge, yes, we got an offer today from the state, so we just asked for a reset, Judge.
All right, how old are you?
19.
All right, Ms. Ferguson, recall this for 30 days for plea deadline date. And it's Denzel, how you pronounce your last name?
Apia.
Apia, all right.
Judge, I have a vacation letter until the week of the 22nd, so is it possible to get that week?
All right, Ms. Ferguson,
It's about 30 days.
what are you, is your vacation letter the week of the 22nd?
Judge, it's from the, I think the 4th to the 19th, so the 19th.
All right,
is a
if you'll put
Friday.
it the week of the 22nd, Ms. Ferguson. All right, July
Your Honor.
23rd is your plea deadline date. Make sure an acknowledgement of discovery is signed. And once you've done that, you're excused.
Thank you, Judge.
You're welcome.
Yeah, excuse me.
Yes.
Thank you.
Who's here on Amberly Perez?
Character one, Connor, we're ready.
Court is calling 2022 CR 6214, State of Texas versus Amberly Perez. Could I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defense?
Eric DeWalt, I represent Miss Amberly Harris.
And are you Ms. Perez? Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
All right, off the record for a moment. You all are gonna have to move down there if you want to talk. No talking behind the court reporter while the court is on the record. And you'll need to ask the deputies to move your client. We're back on the record. Are you the same Amberly Perez who was placed on deferred adjudication in 2022 CR 6214 for the offense of aggravated assault with a deadly weapon on September 13th, 2022 for a period of 7 years?
Yes, ma'am.
All right, state.
Violated condition number 38 in Bexar County, Texas. The defendant Amber Lee Perez did then and there failed to submit to drug testing as directed by the court officer, supervision officer for the month of June, August, and October 2023 in violation of condition number 38.
How do you plead to that? True or not true?
Your Honor, state waives all the violations.
Any objections?
None, Your Honor.
Did you understand by pleading true to violation of condition number 38, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition 38?
Yes, ma'am.
Court will find violation of condition number 38 true. Is there a proposed agreement?
Your Honor, it's to the defendant to go to the safety.
Your Honor, that is the proposed agreement. We are also in agreement. I know Miss Amberly is ready to make a change in her life, and we'd ask that she please be given this chance.
All right, Miss Amberly, here's the thing. You know yourself better than I do, better than your counsel does, the state does, and probation does. You need to ask yourself if you're going to be serious about this probation and if you want to successfully complete it. Sometimes people will say they want to successfully complete probation and they do not do it. What ends up happening is they continue to use, they don't report. So I'm going to give you a choice. I can sentence you to 5 years in the prison today, or you can go to safety.
Safety, ma'am.
All right, state your excuse. And probation, is this your recommendation?
Yes, Your Honor. She was previously ordered safety but failed to self-surrender, and probation feels that she could benefit from the substance abuse program due to her drug program. Problem.
All right. So I regret that I didn't know that you didn't surrender to safety, because if I would have known that, something else would have been done. And that's my fault for not speaking to probation before then. If you fail to follow the court's orders and come back before me, if the state is able to prove up any allegations, you're looking at, if I don't continue, you're looking at up to 20 years in the prison. You understand?
Yes, ma'am.
All right, I'll deny the motion, alter and amend conditions to include safety, and she's to remain in custody until transfer. And I'm going to extend her for 1 year. Is there anything else?
Nothing from defense, Your Honor.
Is there anything else you need from the court to be successful? All right, good luck to you.
Your Honor, may I be excused?
Yes,
Thank you.
you're welcome. Number, what page is she on?
Page 10.
Thank you. All right, who is here for George Hawkins? All right. And probation, this is an application. Court is calling 2024 CR 5390, State of Texas versus George Hawkins. Can I have parties announced for the record for the state?
Andrew Verisatilman.
Defense?
Renee Munoz on behalf of Mr. Hawkins.
And are you Mr. Hawkins?
Yes, ma'am.
Counsel, have you received all the discovery?
Yes, Your Honor.
And did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Hawkins, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it?
Yes, Your Honor.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Hawkins, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of assault of a peace officer or judge bodily injury as a second-degree felony? Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
that's correct, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Hawkins, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 6 years in the prison. The state is silent on your applications. They're taking in consideration 2023 CR 7315, 2024 CR 53389, and County Court Cause number 729000. Did you understand that to be the plea?
Yes, Your Honor.
Defense is at the plea.
Yes, Your Honor.
State is at the plea.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motion?
No, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
I believe contained in Exhibit 1 attachments, Your Honor.
All right, state, you may be excused.
Thank you, Your Honor.
Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. We'll be back on August 1st for sentencing. I will base my decision on a PSI report, the TAP evaluation, and any other evidence that's presented. Do you understand?
Yes, Your Honor.
All right, is there anything else needed other than a PSI and TAP evaluation?
Nothing further, Your Honor.
All right, thank you.
Thank you, Your Honor. This first.
Have a seat, sir.
All right, who are the parties on David Aguirre? Okay, are we here for sentencing?
Yes, sir.
All right, court is calling 2022 CR 1252, State of Texas versus David Aguirre. Could I have parties announced for the record for the state,
Katie Muscore for the state of Texas.
for the defense?
Louis Martinez on behalf of Mr. Aguirre.
And are you Mr. Aguirre?
Yes, ma'am.
All right, was a PSI done in this case or just an evaluation for DVRF?
Judge, I think it was just the TAP that was done. I don't think we did a DDRL evaluation.
All right, does anyone have a copy of the, it's attached, just 1 second. All right, have both parties had a chance to review the TAP evaluation, state and defense?
Yes, Your Honor.
Yes, sir.
Any objections?
No, Judge.
Your Honor.
All right, according to the plea bargain agreement in this case, the state is recommending deferred adjudication. They're taking into consideration 2022 CR 1253 and 2022 CR 1254. Counsel, any information you'd like to provide to the court?
Judge, we're asking the court to accept the plea bargain. Mr. Aguirre, and this is a case where Mr. Aguirre was medically rejected at the time of the offense. It was indicted 2 years later. He was picked up on a warrant 2 years after that. He's had a lot of medical issues. He's on a methadone program now. He's stayed out of trouble since then, and we're asking for those reasons that the court accept the plea bargain. And with regard to any sentencing treatment issues, I'd ask the court just to consider the TAP recommendations.
All right, was there a recommendation? I saw there was a recommendation to felony drug court. Was he not accepted?
Judge, he lives in Comal County with his father, so that provides some
He
issues.
can't do that. All right, are you currently employed or no?
No, ma'am.
So how do you spend your days?
Helping my father,
All right, and what do you help him with?
whatever he needs, his ranch, whatever.
Oh, so you're at a ranch? Okay. All right, this is what the court is going to do. Probation, does there need to be a transfer to Comal County or is that drivable? Okay. All right, the court is going to follow your agreement. Does anybody want to speak to the length of community supervision? It was requested for 8 years.
Judge, I think that's appropriate just with the amount of drugs that were found and the other cases that are being taken into consideration.
And Judge, we don't have a problem with that. If he does well, obviously we can ask the court to review it, and if he doesn't, then he doesn't.
All right, the court will sentence you to 8 years deferred adjudication, taking in consideration 2022 CR 1253 and 2022 CR 1254. There's $1,000 fine that will be probated. There's going to be proof of employment or SSI within 45 days. There's to be no employment as a home health care provider or with minors. There's to be regular reporting by Zoom or in person. There's to be 100 hours of community service restitution. If he's unable to work and he provides medical documentation that he cannot do community service hours, then the court will allow him to pay those off at $7.25 per hour.
Yes, ma'am.
There is going to be an evaluation for the medication assisted treatment program. Also called MET. And there's going to be intensive outpatient treatment with probation. There's going to be 120 sober meetings in 120 days. There's to be no unsupervised contact with minors. And we'll do field visits 1 time per month for 3 months. And then at probation's discretion. Probation, is there anything else he needs? All right, is there anything else you need from the court?
Ma'am.
All right, and probation, I do see in here that he's approved for MIC. So if you'll put him on the MIC caseload. All right, we're off the record for just a brief moment. If there's any issues with MIC or something of that nature, just let the court know, okay? All right, we're going to go back on the record. Did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it and did you sign it?
Mhm.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Ma'am.
Let me give you all these. Here's the thing, we're off the record. You're gonna have to start making better choices, right? Your number one priority should be your sobriety. Do not slip up. Do not bring trouble to your father's doorstep because he's taking you in. You understand?
Yes, ma'am.
All right. Is there anything else you need from the court or anything the court can do to help you be successful in this probation?
No, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Excuse me.
Yes. And everyone, just give me a moment. Oh, it is what it is. We'll deal with it. Oh, yes, it's insane. They did something. No. Oh, no, I know. There's something that has been done. We'll figure it out. Let me put my notes in here. Norm, I think there are gonna be a lot of caps in this note system for me.
Yeah, I've been doing it caps right now, call me too. I used to do everything. Over and over, I have to do that. Yes.
And these are the two dismissals in my other cases. I don't have them up here.
They've been done. I think they were already done.
Okay, all right, thanks.
I'll double check.
All right, thanks. Who's here on Ted Sanchez?
Will be judge. This is off docket, Judge.
Yes.
It's set Monday, but I need to be in Austin. I've got a personal matter I need to attend to.
All right,
Could
is
you
your
just-
client on custody?
He's in custody, Judge. Did you bring him
All right.
Tuesday?
Ms. Ferguson, on Ted Sanchez, let me go to my case in JD. Okay. Fine, okay. And what day do you want it called?
Just the next day, Judge. Tuesday would be fine.
All right, Norma, if you can recall his case for Tuesday. All right, that'll be the 23rd.
Yes, ma'am. Thank you, Judge.
You're welcome. And Norma needs that so she can put the notes in.
I'm getting the key together for you.
All right, thank you.
I'll go get it back.
Who did you think?
Martinez, Aiden.
All right, who's here for Theodore Sanchez? Oh, Theodore Sanchez and Ted Sanchez?
Yeah, same person.
Ah, okay. Okay. All right, who's here on Mariano Rendon?
Your Honor, I am.
Good morning.
Mr. Rendo. That's my.
All right, is this the same as Ray Martinez's client?
Yes, Judge.
Right.
Codependent, yes, Your Honor.
All right, so the plea deadline date on this case is going to be July 25th.
That's fine, Your Honor. And we did get an offer today, and may we be excused.
Once you sign the acknowledgement of discovery and your client signs the reset form, you are excused.
I was gonna ask the court, because we had some e-filing issues last week, I wasn't able to do the e-file request. Can I have till the next court setting to do the discovery
Yes.
acknowledgement, Judge? Because I just need to go and request some of the videos and things like that.
All right, thank you for dressing appropriately for court. So when you come back on the 25th, you'll need to let the court know whether or not you're accepting the state's offer. Do you understand?
Yes, Your Honor.
All right, you're excused once you sign the reset form.
Spot on.
Need to announce on Cunningham. Thank you.
Who's down? Kendrick Ward?
This is the court's gonna, it's gonna be where we're gonna ask for one more setting. There are two cases that are out of Georgetown. We don't have any information on them. I tried looking them up online and there's not even court dates.
And we're here for a contested hearing, Your Honor.
All right, Ms. Ferguson, is this set for a contested? It is. So we're here for a contested.
Okay, my understanding was that it was just the initial PR, Judge.
No, I have it written down from May 28th. It's set for a contested today.
Okay.
So what I'll do is I'll recall you both back for this afternoon. All right, all right, so we'll recall it for 2.
2 o'clock.
Yes.
Thank you, Your Honor.
All right, thank you. Norma, do you see what page Kendrick Ward is on? All right, thank you. Norma, that's coming back at 2. Who is here on Felix Apolinar?
Judge.
Are you ready to proceed?
Yes, Your Honor.
Court is calling 2023 CR 8787, State of Texas versus Felix Apolinar. Can I have parties announced for the record for the state?
Second for the state.
Defense?
Adam Wood for the defendant.
Are you Mr. Apolinar? You need to speak up.
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it? Are you the same Felix Apolinar who was placed on community supervision in 2023 CR 8787 for the offense of repeated violation of court order bond conditions on December 6, 2023 for a term of 8 years? Is that you?
Yes, ma'am.
State.
Your Honor, on or about the second day of May 2024, in Barrett County, Texas, the defendant, Felix Apolinar, committed the offense of evading arrest or detention in violation of condition number 1.
And how do you plead to that? True or not true?
True. And Your Honor, the state will waive and abandon the other violations.
Any objection?
No objections, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you to 8 years in prison?
Speak up. Yes.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is a proposed agreement, Your Honor, yes.
And what is that?
The proposal is for amending of conditions for safety, MIC eval, monthly UAs, and then hold probationer in custody and release only for safety. And of course, within the recommendation, there's the new case will need to be resolved prior to transfer for safety. And counsel and I have an agreement, or the recommendation, of course, which would be to TIC that new number 1, so that way placement wouldn't be an issue, Your Honor.
All right, and what's the cause number for the new number 1?
It is, I have it, Your Honor.
Oh, I have it here, Judge.
No worries. Cause number is CC 733418, Your Honor.
All right, probation, what has he done on probation?
has completed providing a DNA sample, Judge. I don't see that he has completed his SOP. He did have a mental health evaluation, and at that point is when they recommended safety and the NIC unit. He never started his battering intervention program, and I do see that we don't have any drug tests on record for him. He did fail to submit on February 29th, 2024. He hasn't started or completed his parenting courses, and I also do not see that he has started his community service hours.
All right. What have you done? You want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand, state your name for the record.
Felix Apollinario.
All right, what have you done since you've been on probation?
Well, I did have a job for 2 months. Fortunately, I lost it.
All right, so having employment, that's something everybody should do. So,
I did go to NA, and when I was going to NA classes, it was very good. I was very committed to it. Unfortunately, when I started working, due to my hours, I stopped going, and it caused me to do a little spin cycle. But it wasn't until I lost my job.
I can't hear you.
I said, when I was going to NAA classes, they were very good. I was going to the Winter Circle off of Bandera Road. I was working at the Denny's off of Ingram. It was the first break I got in a job in a while. I haven't worked in a while.
So they have NAAA meetings by Zoom. You don't have to be in person, so.
I didn't have a cell phone, but I plan on getting one and taking care of myself as far as a job and just complying with the rules and whatever LC would recommend. So NA classes is no big deal. I enjoy them. It just when I stopped going, it just.
So when you stopped going, what did you start using?
No, I didn't start using right away, but I stopped going, and so.
Now, here's the thing, don't be wishy-washy with me.
No, I'm not.
Just
gonna be
answer my
wishy-washy.
question. When you stopped going, what did you start using? And how often were you using meth?
I relapsed for 2 weeks, the last 2 weeks, and I still.
No, listen to me. How often were you using meth?
The last 2 weeks, I did them every day.
All right.
I went on 2 weeks binge.
All right, and usually meth is not free, so you have to pay for that. So you were finding money to pay for meth.
I had the money at that time, but I should have paid my bond, probation, and I felt that.
And do you have children?
Yes, I do.
Yes. So you were paying for meth instead of paying for your children.
Sorry.
I mean, that's the bottom line. You have children to support. Instead of supporting them, you're using drugs and paying for meth. How did you expect your children to eat? Did you expect them to get a job?
My youngest is 18 years old. He just graduated last week.
Well, they still need support. 18 years old. If they're going to college, guess what? They still need to eat. They need somebody to help them with tuition. They need somebody to provide guidance for them, and you're not doing it. And if you choose to continue to do drugs, and I know it's hard to be clean and sober, but if you're going to continue to do that, you need to just politely write your son a letter and tell your son and tell your children, I apologize. I have an addiction and I just cannot beat it, and I cannot be in your life, and I don't want to continue disappointing you. Showing up in your life saying I'm clean and sober, and then something bad happens, everything falls apart and I just start using again. Do you understand?
Yeah, you're right.
All right. They want to continue you. Probation is saying to continue you. I'm going to give you a choice. Sometimes I can give people choices. Sometimes I cannot. You know yourself better than probation does. Your attorney of the state does. So you need to look deep within yourself and answer this question. Are you going to be able to successfully complete probation? If you feel, well, that's just a knee-jerk reaction because nobody wants to go to prison. So here are your two choices. I can revoke you. I will sentence you to 3 years in prison, or I will follow everybody's recommendation and you will be going to inpatient treatment. Which do you choose?
I do what's best for me and my family, and I want to do the probation because it's important that I be able to complete something. Prison time is easy to do. Anybody can do it. But if I complete this program and prove to myself and my family, it would be much important for me to do this, Your Honor.
All right, this is what I'm gonna do. I'm gonna find number one true. I'll deny the motion. I'm gonna extend you for 1 year. This is what's gonna take place in custody. I want a referral to felony drug court. And if he's not accepted in felony drug court, then he's going to safety.
Yes, sir.
And then once he's released from either of those programs, it's going to be 120 sober meetings and 120 days, and all previous conditions are to remain in effect. Is there anything else you need from the court in order to be successful? Anything that the court can do that can help you maintain your sobriety?
That'd be good enough. I'll just do my part.
All right, and what case is being taken in consideration?
It's that county court cause number, Your Honor. Council reviewed it. It would be the 733-418.
All right, and the court is taking in consideration 733-418. All right, we can go off the record. Here's the thing, the court is always here, probation is here. Obviously, probation in the state want to continue to work with you. Can't work with you if you disappear. Do you understand? From here on out, everything you do, you need to ask yourself, could this result in me going to prison for 8 years? Whatever you need to do to maintain your sobriety. I always tell people you need to do it for yourself, but if you don't think you're worthy of being sober, then do it for your child. If you don't think you're worthy of being sober, maintaining your sobriety, then guess what? Say, you know what, but I don't want to do 8 years in prison. So I'm going to remain clean and sober because I don't want to go to prison. You understand? All right, good luck to you. Thank you.
Thank you, Judge. 95.
Yes.
I'll run it next door. Thank you.
All right, thank you.
Of course.
All right, bye-bye. All right. And number, what page is Apolinar on? Thank you. You know what? I prefer the other docket. It was so easy to find things. All right, Norma, on Nicholas Courtney, is he in custody? All right, Mr. Courtney, we're going to recall your case. Your attorney is ill. All right, Ms. Ferguson, let's recall it in, you think 14 days? All right, what date do you want to put it on? All right, Mr. Courtney, we're going to recall you back on July 8th. If for some reason your attorney wants to be brought in sooner, or once you brought in sooner, we'll do it. All right, thank you. I'm sorry, what did you say? All right, thank you. Aiden Martinez. Is the attorney here for Aiden Martinez?
You just caught me. I was getting ready to walk. And then I wouldn't have come back until like 11:59.
Yeah, then you would have been rushing and I would have said, I'm not here. I'm on lunch break. You see me, but I'm not here. All right, where are we on DPS labs?
So Judge, I think Hank was supposed to turn it in. We reached out to see if Hank had ever reached out to DPS to get it. If not, we'll do it immediately.
All right, Ms. Ferguson, on this case, recall this for 30 days. And this will be the last date for labs.
Thank you.
Yes.
Thank you, Judge. Appreciate it.
Oh, well, you need a date, or are you just gonna come back whenever y'all want to?
Say that again.
You need a date, Mr. Martinez.
Tell them to wait on the other side of them.
Come forward.
You're gonna give them the date.
Yes. And what date? All right, so you're gonna be back on July 18th. Once you sign the reset form, you're excused.
Thank you.
All right, thank you.
Where was near ears? I almost busted out on Jess. But
No,
that's for Zoom. Okay.
Thank you, Judge. Appreciate
You're welcome. Oops. Who's here on Willie Cunningham?
Judge.
All right. Hello, today is plea deadline date.
Yes, Judge, and we do not have an agreement, so
All right, State, how long do you expect this trial to last?
I don't think it would last longer than
3 days.
3 days. Yeah.
All right, Ms. Ferguson, on Cunningham, I need a reset date for trial, family violence, 3 days. And I don't have a copy in my file of acknowledgement of discovery. Did you all complete one?
I don't think we did. So I was looking too, because I see my red tabs, but at an abundance of caution, I'm just gonna redo one today if that's okay, Your Honor.
Yes, thank you.
That's all good.
Sure.
All right, we'll come back on August 12th and you'll be in impact court. So you'll report on the second floor. All right. All right, once you sign the reset form, you're excused. Thank you for always dressing appropriately for court. Who's here on Mark Johnson? I'm sorry, Joshua Mackay.
Right here.
And then after that, it will be Richard Rodriguez. On Mackay?
It was on I went to the air, sir. Jaden's bottom.
Ah, I see it. All right, so what are we here for on this case?
Judge, we're set for initial setting on an MPR. I've conferred with the state. We're requesting a 3-week reset to resolve one of the violations. And then I believe we will have an agreement on the MTR. But the state wishes for us to provide some type of proof that this new number 1 is going to be dismissed out of Harris County. So we're just requesting a short continuance to get that accomplished.
All right, Ms. Ferguson. Reset this for a contested in 2 weeks. That's the last setting you all will have.
Judge, you when you set his bond, you put a condition of GPS. We're asking the court to possibly reconsider putting that on. He has until the 24th to have the GPS put on. This is his first MTR after 9 years. He has shown up to court every time. We're asking the court to reconsider placing that GPS condition on.
No. All right, Ms. Ferguson, what date? All right, we'll be back on July 9th. That will be a contested hearing. All right.
Absolutely. Yeah, thank you.
All right, thank you. Once you sign the reset form, you're excused. Thank you for dressing appropriately for court. And let me find what page he's on.
I don't think it made the docket, Judge, but it was supposed to be set today.
Ah, okay. Thank you.
Well,
Everyone, the court is recessing at noon. Who is here on Richard Rodriguez?
Present, Judge.
Okay. And probation, this is an application. Court is calling 2024 CR 5668, State of Texas versus Richard Rodriguez. Can I have parties announced for the record for the state?
Is that done for the state, Your Honor?
Defense.
Renee Munoz on behalf of Mr. Rodriguez.
And are you Mr. Rodriguez?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, that's correct, Judge.
Court will find that the state is in compliance with discovery. Mr. Rodriguez, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Did you review the document entitled Court's Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with assault family second offense? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that did you understand that by entering this plea today, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison.
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as the factual understanding of the charges against him?
I do.
Do you believe he's currently competent, was legally sane at the time of the offense?
That is correct.
Mr. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, the state is recommending deferred adjudication. There's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, sir.
Did you understand that to be your plea?
Yes, sir.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 5 years. There be a TAP evaluation and no harmful or injurious contact with Angela Cervantes. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State offer states 1 and attachments.
No objection, Your Honor.
And state, have you spoken with the complainant?
We have been able to get a hold of the complainant, Your Honor, and they have made it clear their lack of interest in supporting the district attorney's office.
All right. You may be excused. Did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
If we may, Your Honor.
All right, the previous assault case he has, who was that alleged? Well, not alleged. Who was that against?
Angelo Cervantes.
The previous one. you-
Oh,
that time-
Amber Rose Jimenez.
All right, Amber Rose Jimenez, and now it's Angela Cervantes,
Yes, ma'am.
what is your issue?
I don't have an issue.
Well, I mean, you're here for your second assault, so obviously there's an issue. It appears that she wanted you to leave her residence and she was breaking up with you. Was that your residence?
I was living there at the time.
Was your name, was it an apartment?
No, it was a house.
Was your name on the lease of that home? Yeah, so she didn't want you there anymore.
Right.
So you don't have anywhere else you can go?
Well, no, not at the time I didn't.
Do you have any family members?
Yes, ma'am.
Mom, dad?
Yes, ma'am.
Are they in Bear County?
Yes, ma'am.
So why can you go to them?
Oh, I can now.
No, I mean, why can you go? I would like to think, and if I'm wrong, tell me I'm wrong. If somebody were to kick you out of their home today, there is a family member where you can knock on the door and say, hey, I just got kicked out. Can I stay here?
Right.
As opposed to, according to this, they found you in a drainage ditch. So what don't you understand when people don't want to be with you?
Mhm.
Sean, I think he's had a lot of time to mull that over. He's been in custody the last 4 months, and I asked him specifically about this instance, leading up to his arrest. He said that it was out of character for him. He just found out it was a toxic relationship with this individual. He stated he's not going to even consider getting back with that individual, that bridge has been burned, and he's looking more so to work on himself. And
So why is outside the agreement no harm for injurious contact with Angela Cervantes?
I think it's because Judge, she didn't really want to testify. I don't think there would be any issue if it was a change to a no contact order. She didn't really want to proceed because she stated to me, and I believe the district attorney's office, that I was out of his character as long as she has known him, and she doesn't want him to be confined more than he's already been confined for the last 4 months, Judge.
All right, so it may be her experience that it's out of character for him, but he has a previous assault case. You can't go around hitting on people. Guess what? When a relationship is over, you need to leave. And if you are in a relationship with somebody, and either if it's the female or the male or whoever's in the relationship, if you get to the point that you want to put your hands on somebody in violence, don't do it. You leave. That's when you know the relationship is over. If you think someone is cheating on you, you have a choice. Either I think this person is cheating on me, but guess what? I'm going to accept it and stay with them. Or either I'm not going to accept it. I'm going to leave. It never should get to the point of violence. Do you understand?
Yes, sir.
And what is the tattoo on your neck for?
Oh, this is my daughter's name. So-
All right, that's good. I always tell people, if you're going to put a name on your body, it should be either your mom, because they're supposed to love you, or either a child, because you're always supposed to love them. When's the last time you were employed?
Let's see, about 6 months ago or so. I never had a problem having a job. Always had a job.
How many children do you have?
3.
What are their ages?
Got an 11-year-old boy, 10-year-old girl, and a 9-year-old boy.
All right. So do you have the 11-year-old and the 9-year-old's name on your body? That's either yes or no.
No.
All right. So do they feel like maybe you don't love them as much because you have Sophia tattooed all across your neck? Where's the 9-year-old and 11-year-old's name?
Right. Well,
I mean, these are just questions.
I know, I just,
Down the pipeline, Judge.
I don't know how that's relevant, but,
Because I'm asking it
okay,
and I want
well,
my
I will-
questions
I will
answered.
maybe soon get it.
No, I mean, you don't have to. I'm just wondering,
Okay.
do your children feel some sort of way if you only tattoo one child's name on your body?
She may be the princess, Judge, because
Yeah,
it's the
she-
girl, so that's why
Oh.
it's catered to her.
Well, he should put Princess Sophia.
That may be coming too. I don't know. Hopefully not. Want to hopefully stray away from any more ink at this point. Richard.
Any drug use?
No, ma'am, I've been clean for a year.
All right. And what was your previous drug?
It was methamphetamine. I was on it for 12 years and I've been recovered addict for a full year. That's probably,
And how far did you go in school?
graduated high school.
And what type of employment have you had?
I've been a cook for the past 13 years.
Where?
Denny's, probably every Denny's in San Antonio, Metropolitan Methodist Hospital, Northeast Methodist Hospital, Cracker Barrel, IHOP.
Breakfast places or diners, companies like that.
Breakfast places.
And if you're released, who would you be living with?
My mother.
All right, have you asked her if you can live with her?
Yes, we have gone over just briefing about it, but I'm sure I will be able to.
Well, no, people always assume they can live with their parents, but did you talk to her and say, Mom, when I get released, may I live with you?
Yes and no.
What does that mean?
Kind of put it out there, but
And she hasn't picked it up. So you threw it out there and she hasn't picked it
I'm
up.
sure she will say yes. Sure she will.
So we don't know where he's going to be living. So this is what the court is going to do. The court is going to sentence you to 6 years deferred adjudication. There's to be no contact with Angela Cervantes. There's to be regular reporting by Zoom or in person. There's going to be 100 hours of community service restitution. I'm going to order parenting classes. Once he completes parenting classes, the community service hours will be deemed satisfied. And the children that you have is Angela Cervantes the mother of any of them?
No, ma'am.
There is to be an affirmative finding of family violence, the BIPP course. And I'm going to order that he stay at lifetime recovery.
Well, there's actually a ministry that I was staying with before. It was San Antonio Christian Church Discipleship School and Ministry off Days of Honor Road.
Mhm.
And from there, kind of got taken out, moved in quick with Angela. Lived with her for about 3 months, and it was a vicious cycle of her kicking me out
All right.
and calling me back.
Oh, well, we're going to help you out right here. So I'm giving you your orders. You're going in lifetime recovery. There's going to be a TAP evaluation. What's the length of time of TAP in custody? All right, so that'll be a TAP evaluation while in custody as well. Follow TAP recommendations, 120 sober meetings in 120 days, proof of employment within 30 days, no employment as a home health care provider with minors, no unsupervised contact with minors, and field visits one time for 4 months. There's to be regular random UAs. And then regular reporting, I already said regular reporting by Zoom or in person. Probation, is there anything else he needs? He's going to be staying at lifetime recovery. And you're going to be at lifetime recovery until I allow you to leave lifetime recovery. So there will be none of this. I just met a new girl, so I'm leaving lifetime recovery. Do you understand?
Yes, sir.
All right. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right. Is there anything else you need from the court to be successful?
No.
All right. We can go off the record. So let me just tell you something. Do I want to be in anybody's business? No. I would love if we lived in a world where everybody could be in their own business instead of being in other people's business. I ask questions because guess what? The only thing I know about you is that you've assaulted a person twice, somebody that you've been in a relationship that you supposedly love. That's all I know about you. So I ask these questions so I can learn more about you. For example, the name Sophia, who is that? Is that some other female that you've gotten so deep in that you want to put her name on your neck? Do you understand?
Yes, sir.
All right, good luck to you.
Thank you, Judge. Maybe excused.
Yes. Yes. John Martinez.
The motion.
Okay. Yes, I have that.
Good morning, Your Honor.
Good morning. I see that. I know that he's set for the 27th, but we're here on these motions.
Yes, Your Honor.
All right, is his girlfriend here?
Yes, Your Honor.
All right. Court is calling 2024 CR 4455, State of Texas versus John Anthony Martinez. Could I have parties announced for the record for the state?
Zach Dunn for the state, Your Honor.
Defense?
Leah Alon here with Gary Barton's office representing Mr. Martinez.
And are you Mr. Martinez?
Yes, ma'am.
All right, there's a motion here to amend bond conditions. I believe that is the aggravated assault with a deadly weapon is the complaining witness, the defendant's girlfriend?
Yes, Your Honor.
All right, and I believe that she wants the no contact order lifted.
That's the state's understanding, yes.
All right, state, are you in agreement with lifting the no contact order?
We let council know that they had two separate motions, one for the GPS, one for the no harmful. We were in agreement to the, well, depending on the former or latter with respect to partial to monitoring, Your Honor.
Okay.
But we almost essentially, we're happy to, if the court would like our recommendation, we almost stayed silent, given we were hoping to hear from the complainant, given their presence in the courtroom today.
All
With
right,
respect-
so with regards to GPS, then the court will allow for tracking. Now, anyone want to call the complainant?
Yes, Your Honor.
All right, so before you all call her, is this an issue where the complainant is going to come and say this didn't happen?
If my understanding is correct, it's not so much a reneging or taking back that something happened, so much as it's a putting forth a complainant's intent to not assist in prosecution is the state's understanding.
All right, because if she is, let's call her up. What is her name?
Her name is Shania Hernandez, Your Honor.
Shania Hernandez, come forward.
I believe she is outside of the courtroom.
Yes.
May I go get her?
Yes.
Martinez. Stand right here, put your back against. Oh, it's the arrow man.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand, state your name for the record.
Shania Hernandez.
All right, Ms. Hernandez, if you are coming in to say that this did not happen, then you will need an attorney to represent you. I'm not saying that the state would file charges against you, but it is a crime to file a false police report. Do you understand?
Yes, sir.
All right, so are you coming forward to say that this did not happen? All right. Anybody wish to ask her questions?
Yes, Your Honor. If I may, could you please spell your name for the record
SHANIA
and your last name?
HERNANDEZ.
And can you describe the nature of your relationship with Mr. Martinez before the incident?
We were in a long-term relationship with a.
I'm sorry, I cannot hear you.
Sorry, we were in a long-term relationship with a kid.
And how many children do you share together?
One, boy,
And how old is your child?
2 years old.
And since the incident, have you had any contact with Mr. Martinez?
No, ma'am.
Have there been any violations of this no contact order?
No, ma'am.
And do you have any safety concerns specifically as they relate to Mr. Martinez?
No, ma'am.
And has it been challenging to avoid contact with Mr. Martinez for yourself and your son?
for my son. It's just kind of hard doing all this for myself and not having, the parent that agreed to become there.
What sort of difficulties have you experienced?
Like on weekends, I always have to find somebody to watch him because his daycare doesn't carry through on weekends. So it's always me trying to either get a family member to help or, sometimes it's hard being able to get diapers and everything, what he needs throughout. And I don't really have anybody to ask for help.
And do you have any concerns or reservations about modifying the bond conditions in this case?
No.
I'll pass the witness, Your Honor.
No questions, Your Honor.
All right, I have a few, if there are no objections.
No objections from the state.
How old are you?
I'm 22 years old.
And how long have you been in a relationship with him?
3 years.
All right, and how does your family feel about your relationship?
Mm,
Are they opposed to it? Were they always opposed to it, or they just now are opposed to it?
They're just not opposed to it.
All right. All right, thank you.
Thank you.
Oh, you can come back. Any other evidence?
Nothing from the state, Your Honor.
All right, so this is what the court is going to do. One, I'm not allowing him to have face-to-face contact with her. According to the indictment, and I don't take any of it as true. I'm just here on an aggravated assault with a deadly weapon, but it's alleged you pointed a firearm at her. So I will allow him, because she's saying she needs diapers, she needs this. He can call, I think they do, what is it, DoorDash or whatever they do. I know you can order at the grocery store and they will deliver it. So you can, if you want to help take care of your child, guess what? You can go online. I will not consider it a violation if you're ordering Pampers or whatever food items you want to have delivered to that home, but you're not allowed to deliver it. Do you understand?
No.
You're not allowed to have contact. If there is some sort of agreement regarding the child, I have no jurisdiction over the child. If somebody has legal documents where he can have visitation with the child, that needs to be done through a third party, not through her. So the only contact you are allowed to have with her is having groceries delivered.
Could I have my mom deliver anything to her?
Yes, your mother can deliver items to her as well. You are not allowed to have face-to-face contact with her. State, do you have any objections to him maybe having, I don't know, I guess Zoom time with his child?
No objections, Your Honor, and I think providing him any civil documentation would also help the state in the future with respect to the child, so
Okay.
absolutely, Judge.
All right, so there's to be no in-person contact with the complainant. So that means that you can have contact by Zoom. You all want to talk and you want to see the baby through Zoom, you can. But you are not allowed to go to her place of employment if she's employed. You're not allowed to go to her residence. If there's a family barbecue and she's there with her family, even if the baby's there, you're not allowed to come over. You understand? Is there anything that you do not understand about the court's instructions? All right, so there's to be no in-person contact with the complainant, and GPS is tracking only, and the court is asking that fees be waived. All right, is there anything else?
Nothing from defense.
All right, we'll see you back on June 27th.
Yes, sir.
Thank you, Judge.
You're welcome.
Excused.
Yes.
Thank you. Okay.
Okay. All right, let me just tell you what cases we're going to take up before the break. Anything that's not called, you're going to have to come back this afternoon. All right, so it's going to be Tucker, Torres, Armando Garcia, and Brittany Brown. Brittany Brown. Oh, yes.
Do you have the Zavala violation?
Yes, I'm going to take that up. All right, who's the attorney for Brittany Brown? All right, come forward, please.
So, Your Honor, we were not ready on that. File just got handed up there a little early.
Okay.
We're almost ready though, Your Honor.
All right, Albo Tucker.
Present, Your Honor.
All right, what is happening with this case?
Your Honor, I'll just appointed to Mr. Tucker's case. We found a resolution. I'd like to bring him back probably on Tuesday. There are some misdemeanor charges as well that he needs to plead to, and we need to make sure that he pleads in the misdemeanor court as well on that day. I want to coordinate that. If we can come back on Tuesday, that'd be wonderful.
All right, Ms. Ferguson, on Tucker, if we can recall this on Tuesday, and that would be the 25th. All right, is there anything else?
That's it, Judge.
All right, thank you.
Thank you. See you on Tuesday.
Yes, sir.
And let me
Thank
see
you,
what,
Your Honor.
you're welcome.
Have a blessed day.
Oh, thank you, you too. Armando Garcia,
Present, Your Honor.
are you ready to proceed?
No, Your Honor. Apparently there are new number one cases that just happened about 3 weeks ago, aggravated assault of a public servant. I've been appointed onto those. I haven't gotten any discovery on them. So what we'd like to get a reset so I can research that and we'll go from that point.
And Judge, on that one, I looked into it. All we have on our end so far is just PDFs, just the reports. I don't even think an intake attorney's been assigned to it yet.
All right, Ms. Ferguson, on this, can you recall it in 45 days? We're gonna bring you back in 45 days. If your attorney wants you brought back sooner, he'll let us know.
Yeah.
And it is Armando Garcia. All right, we'll bring you back on August 5th. And Norma, set that as a discovery. Thank you.
I'll be back in touch with you before then, okay? All right, thanks, sir. Thank you, Judge.
You're welcome. Who's here on Jalen Zavala? Good morning. All right, so on this one, there's an issue with payment, correct?
Yes, Your Honor.
All right, is she able to pay?
No, Your Honor. So I was appointed to represent Ms. Zavala in January of this year. She was arrested for the state jail felony offense of driving while intoxicated with a child passenger. The court did permit her to have an in-home device. However, Ms. Zavala lost her job and has been unable to secure employment. As such, she fell behind on the calibration scheduling for that in-home device.
All right, where has she looked for employment?
So Judge, from May 29th through June 10th, she's applied at multiple different,
What places?
she was working at Amazon in January, and then she's now applied to Walmart, to a staffing agency called Balances Staffing.
All right, they're hiring at Chick-fil-A, they're hiring at McDonald's, they're hiring at Burger King, they're hiring at Whataburger.
And she's applied to Dairy Queen, Auntie Anne's, as an optical sales associate somewhere else, Snowbird, Shaved Ice. So she's made
Okay, I
an
think you
attempt
should
to-
apply, try McDonald's, Walmart, Whataburger. Is he talking to someone?
Your Honor, I'm not sure.
Who is speaking to the inmate? Who are you speaking to? I'm sorry, who? Where is he? Yes, you're excused.
I was trying to give him this letter. Give his lawyer, I'm trying to figure out.
Give it to the deputy and then you're excused. All right, thank you.
So Judge, she has been making those applications. I was going to see if the court would consider possibly waiving that in-home device. Ms. Zavala, while she was arrested for that DWI with child, there is an exception under 17.44B. It says a magistrate can waive an alcohol monitoring device if it's not in the best interest of justice. I guess for the court to make that decision, the court would need to know that when she was arrested for DWI, she was incredibly cooperative and compliant. She did provide a breast specimen and it came back at a 0.01 and a 0.02 respectively. So it's not alcohol that was the issue. I don't know whether drugs are on board or not. However, it is my understanding that the state has submitted the blood, which she did consent to provide a specimen of to
DPS for a toxicology exam.
State, do you want to waive the in-home device or no?
17.441B, Your Honor, and it is at the discretion of the magistrate if you find that it is not in the interest of justice.
Well, I know, but are you in agreement with the waiver of it?
Yes, Your Honor.
All right. Then what are we going to do instead of that?
Well, Your Honor, she's not driving. She doesn't have a vehicle. I don't know whether there are drugs on board. The report doesn't seem to indicate that there is any sort of presence of drugs. I would say possibly maybe if you would want her to submit to a weekly UA. Transportation has been an issue because she's not driving and she's been relying on her father to get her to different appointments, and he does have a full-time job.
All right, this is what the court is going to do. The court is going to waive the condition of the in-home breathalyzer. I'm going to order no driving. So you're not allowed to drive. Do you understand?
Yes, ma'am.
And I'm going to order sober support meetings. And you can do those by Zoom. And I'm going to order 60 sober support meetings in 60 days. And there's going to be regular UAs. And I'll waive the fee. And I'm going to have them test for alcohol. And those UAs need to be once per week.
Yes, Judge.
All right, is there anything else? All right, thank you.
Thank you.
Thank you. You're welcome.
May I be excused, Your Honor?
Yes. Jaime Torres.
Present, Your Honor.
All right, are you going to have witnesses?
Yes, Your Honor.
All right, let's call this back in the afternoon then. Norma, Jaime Torres is going to come back at 2. Yeah, all right, we'll bring you back at 2 with your witness.
Yes, Your Honor.
I'm sorry, this is Jaime Torres. Manuel Sandoval. Are you all ready to proceed?
All right.
Court is calling 2023 CR 3142, State of Texas versus Manuel Sandoval. Can I have parties announced for the record for the state?
Zach Dunn for the state, Your Honor.
Defense?
Matthew French for Mr. Sandoval, ready.
And are you Manuel Sandoval?
Oh, yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Manuel Sandoval who was placed on community supervision in 2023 CR 3142 for the offense of assault family, second offense on August 29, 2023 for a term of 6 years? Is that you?
Yes, Your Honor.
State?
Your Honor, on or about the 9th day of January, 2024, in Bear County, Texas, the defendant, Manuel Sandoval, did then and there fail to attend and complete Bear County CSCD's Substance Abuse Intensive Outpatient Treatment Program in violation of condition number 30.
How do you plead to that? True or not true?
True, Your Honor.
And the state will waive and abandon the other violations, Your Honor.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 30, the court could find it true, grant the motion, sentence you up to 6 years in the prison and up to a $1,500 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 30?
Yes, Your Honor.
All right. Court will find 30 true. Is there a proposed agreement?
There is a proposal, Your Honor, yes.
Yes.
I think state had let it be known to council, you know, the drug use was a primary concern. Following the recommendation for amending of conditions to include SATF followed by aftercare. And I know council wants to speak on some more things, but that is the proposed recommendation.
All right. So I'm not going to follow that agreement. This is not his first motion to revoke, and I had already previously put those conditions in place, and there has been no follow through.
Well, he's not been into an inpatient treatment program, Judge. He's agreed to do that today. Judge, just a little bit of background. He was having difficulty. It's referenced in the reports to the court. He was having trouble with finances, keeping jobs. He was doing odd jobs. He's also in this time period, Judge, his father was diagnosed with prostate cancer and has been given only about 6 more months to live, which is, the time is ticking on that as well. So he has some other issues that he was dealing with. He understands the situation. He's asking the court to follow that agreement. I understand the court's concerns about it, but drugs seem to be the issue for him, and he's willing to go to that inpatient treatment, Judge. He still has quite a bit of time left on probation, so the court could continue to monitor him after that drug treatment.
All right, this is what the court is going to do. The court is going to grant the motion. There's an affirmative finding of family violence. The court will sentence you to 3 years in the prison, give you credit for any time served. There's to be no contact with Sands, S-A-E-N-Z, Andrade. I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
So do you want?
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegation in the motion, not the fact that you are on community supervision. The court will request therapeutic community for you. Whether or not you're placed in that is not in my jurisdiction to order, but I know they will definitely not consider that for you if you do not request it. It does not increase the time that you're in custody. You understand?
Yes, Your Honor.
All right, good luck to you.
Thank you, Judge.
You're welcome.
Have a seat, sir.
All right, Brittany Brown. Are y'all ready to proceed on this motion? All right, I don't have, let me see. I don't have a trial court certification.
That's my bad.
No problem. No problem.
My shoe out of it.
All right, and could I get a file stamp?
I'm sorry.
That's okay. Court is calling 2023 CR 0042, State of Texas versus Brittany Merrill Brown for the state
Zach Dunn for the state, Your Honor.
and for the defense.
Criminal defense. Your Honor, would you like her to just sign this after?
Yes, you can sign it now. Oh, no problem. No problem. And are you Brittany Brown?
Yes, ma'am.
Are you the same Brittany Brown who was placed under deferred adjudication in 2023 CR 0042 for the offense of assault bodily injury married on February 6, 2023 for a period of 2 years? Is that you?
Yes, Your Honor.
And did you review that motion with your attorney?
Yes.
All right, state.
Your Honor, on or about the 6th day of May 2024 in Bear County, Texas, the defendant, Brittany Merrill Brown, did then and there fail to follow all TAP treatment recommendations as directed by the court and or Bear County Community Supervision Department in violation of condition number 15.
How do you plead to that? True or not true?
True.
All right, did you understand by pleading true to violation of condition number 15, the court could find it true, grant the motion, find you guilty, sentence you up to a $4,000 fine and up to 1 year in the Bear County Jail? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 15?
Yes, Your Honor.
Court will find violation of condition number 15 true. Is there a proposed agreement?
There is not, Your Honor.
All right, state, what are you requesting?
The state is requesting an extension of community supervision for 2 years and an amendment for DDRF as recommended by TAP.
All right, this is a misdemeanor case.
Your
So,
Honor, may I say something?
you want to raise your right hand?
Yes, ma'am.
Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, yes, what would you like to say?
Well, I was gonna go to the SATA program and they told me, they came and saw me, and they were like, get off their medication and you can go to our program. So I got off the medication and then they still denied me. And like, I've been here since January, away from my kids. Like, I was just hoping I could have another chance to do outpatient. I'm hoping for another chance, Your Honor. I'm begging for another chance.
Okay,
That's all I have to say.
all right, this is what we're gonna do. We're gonna come back at 2:30 and I'll give you my decision at that time, okay?
Yes, ma'am.
All right, thank you.
Thank you, Judge.
All right, everyone, so we're gonna go on our break.